95.3 WDXE.
Wow, we let the time slip on us just about there. That was my fault.
We were Fridaying.
Oh my gosh, it's Friday already.
We were Fridaying. Yeah.
It is Friday. It's Stan Pierchoski. It's the Stan Pierchoski Hour. Estate plan Stan. That's right.
Bulletproof estate planning.
That's
what
right.
we are. That's what we call ourselves. Yeah.
Yeah.
Yeah, we do this every Friday from 8 to 9. We're going to talk about a few things this morning, and we like to remind folks that this is an interactive show. So call in with questions. I get some good ones, and I love answering questions. So if you have a question and you're like hesitant to call,
yeah,
I mean I really do enjoy it. So call,
yeah,
let it rip, and we'll talk about it. If if it's personal, we'll make it generic. But anyway, the call-in number is 931-766-9393.
That is the number.
And so call in and ask a question. We're gonna talk about a few things. First thing I just want to mention is that next week, a week from tomorrow, February the 17th.
Yes.
Okay, that's a week from tomorrow, Saturday. We're holding my next seminar here locally. The last one I did kind of locally, meaning Giles or Lawrence County or Murray County, was back in November.
Okay.
And so we're back around. We're going to be here at the WLX radio station in the back of the building on the 17th. When we do Saturday seminars, they start at 10 o'clock in the morning. We start pretty promptly. And, we call it Wills, Trust in the Nursing Home. So if you have questions, and if you want to come to that, call my office, which is 931-363-7222. And just tell the girls, you'll talk to either Miss Alex, Miss Tammy, or Miss Courtney, and you will just tell me when to get on that list. It's an RSVP list, but it's informal. We just like to know how many are coming.
Sure.
And then, or if you can't commit and you decide at 8 o'clock in the morning that, hey, let's go to that thing, just walk in. We here at WLX in the back, what they call the Country Cafes, a pretty big venue.
It is.
A lot of tables, a lot of chairs. So if we have, and we always have walk-ins, and that's okay. I often say, really, the main reason we want a head count is so we can set out enough tables and chairs.
Yes.
And maybe even the biggest reason is so that the girls that make the light refreshments we have,
yes.
There's nothing worse in a woman's world than to make refreshments and fall short.
Yeah, they won't have. So, they want to make sure they have plenty.
Yeah, the head count is probably more important for that than it is for putting out tables and chairs. And that's all. We just need to know. So, if you want to come to that, if you haven't been to one of my live seminars, I think you will enjoy it.
Well, it's certainly informative, no doubt.
Yeah. Now, it lasts about an hour to an hour and 15 minutes. I mean, it just depends. I try not to get off on a tangent, but sometimes it does. But typically, and then what's really interesting is after the presentation, I stick around for as long as necessary to answer questions. And that's when a lot of people fire some really good questions. And one good thing about the question and answer period is when people have questions about this, most people have the same dozen questions, basically.
Yes.
So when somebody asks a question, it really is beneficial. The answer is beneficial to everybody there.
Absolutely.
That happens a lot. And so you're welcome to stay and listen to the question and answer and ask a collective question. I also tell people, if you've got something that's personal or sensitive, if you don't mind, if you stick around and catch me on the side after the seminar, I'll be glad to talk to you individually if it's something you just would rather it be private, not a collective question. No problem. I often say I'm the last one out for two reasons. One, I like to answer every question, and two, I got the key, and I have to lock her up. I have to lock up behind me. So, it's not tomorrow Saturday, but the next Saturday, the 17th.
The 17th,
10 o'clock. I like to start as close to 10 as I can, and if people say, "Well, what can I expect when that comes?" Well, here's what you don't have to expect.
Yes.
Or don't expect. We're not having a meal and a foofy sales pitch and kind of a willy-nilly talk and what it is, it's a structured presentation. I'm going to go over things like what a will is, what a last will and testament is, what a trust is. Then we break into the asset protection portion of it, which is what we call protection from the nursing home. Sometimes I call it how not to go broke in the nursing home, but really we're dealing with how to deal with the high cost of long-term care.
Yes, exactly.
And the reason I start with a will versus a trust and talk about that is because the solution to this long-term care problem is a trust. And if you haven't been exposed to trust, I'd like to cover it at least briefly, what a trust is and what it does. And so we talk about the will and the revocable living trust for about the first half of the seminar, and then we break into the long-term care aspects and asset protection in the second half. And it usually goes over pretty big. People are usually pretty pleased with the the results of it, with the information they learn. Like I say, if you have a question, bring it with.
Yes.
If you get a question during the presentation, write it down, and when we get the Q&A, lay it on me. I'm more than happy to do that. I don't know how to express that any more than that I encourage questions. We call these free educational seminars. I really think the key word I want to focus on is educational. So don't come to a seminar and leave it with a question unanswered. I mean,
Yes.
just take advantage of my time. I offer it freely. It's not an imposition. There's no such thing as a silly question. People often say this is a silly question, but how do you learn stuff if you don't ask?
If you don't ask, that's
don't
right.
seek the answer,
That is right.
It's not a problem. I commend you for asking a silly question because you're trying to figure it out. You're trying to learn. I don't want to do trust and wills for people that have no understanding of what we're doing.
Sure.
That's not the way
Absolutely.
I practice law. I want you to understand what we're doing. I want you to see that this is a good fit for your family, stuff like that. So anyway, well, I'll bring that again up at the end of the hour when that is. So, but speaking of seminars, I gotta talk about an experience,
Oh, okay.
and I want to talk about it in a context of the folks that listen to me maybe on this radio station that haven't come to the seminar or have heard about me and maybe don't know that much about me. I want to cover something, and that is when I started doing this, estate planning. I used to do a lot of criminal work, criminal defense. I did that for years.
Yes.
And maybe more, probably 10 years at least. I did a lot of trial work. Okay, I mean, I tried murder cases. I was one of a few attorneys in Tennessee, or a handful, that are death penalty qualified. I actually did a death penalty case, stuff like that. I did that for years. But at some point, I transitioned to estate planning, which is all I do now. And when I did that, I had a certain, I don't want to call it a business model, but I had a certain vision in mind. And that vision was something like this. I'm a sole practitioner. I'm not a sole proprietor. I'm an LLC, but nonetheless, I'm the only attorney. And I've only ever been my own, hang up my shingle and just be me. Okay?
Yes.
I often say I'm too old to be with other folks, and I don't play well with others sometimes. So I like to be on my own because I like to do things that are little non-traditional. And so I decided my vision was I really wanted to break the typical attorney mold for people that come to see me. I know when you go to see an attorney, it can be an intimidating experience. Okay, and I think I'm up against years and decades, if not centuries, of people's perception of the legal community.
Oh, yeah.
That's a tough road for me to hoe because people have a preconceived knowledge long before they ever hear a word I say or meet me about lawyers. And some are really bad, some aren't so bad, and some just say, I don't know, I've never been to one, so I don't know. But I know if I go to one, it'll be intimidating. And I really wanted to get rid of that because in estate planning, we're going to talk about your family dynamics, issues you need to solve. I mean, not super personal, but it's kind of personal.
Yeah.
And I want people to be comfortable with that. So my vision was I'm going to transform my law office to look a little more like somebody's living room. Because you have bookshelves of books, and it's like we got rid of that. I don't wear the suit and tie anymore. I mean, if I have to go to court, which is rare, I have a suit and tie to put on in my office. But I look like I look now.
Yes.
Real casual. And I never. I know a lot of people come to me and say, "Well, I had an attorney for this, and he sent me an email, and I got a bill for 0.1 hours." Okay. Now, if you're an attorney that does that, I'm not saying don't do it. I'm just saying I'm not going to do that.
Yeah.
I don't like the perception it creates when you do it.
Yeah.
I'm taking the position that there's no way I can justify that my time is so important that I can't do 0.1 hours, which is 6 minutes.
Yeah.
Right?
Yeah.
Let's do the math.
Yeah.
0.1 hours is 6 minutes. That I can't offer 6 minutes to somebody and not send them a bill.
Yeah.
I just, if you think your time's that valuable, then bill.
Yeah.
It's not that I don't think my time's that valuable. I just don't think I can accomplish anything in 6 minutes for somebody that I can bill for. Okay?
Yes.
So I don't do that. And I want that, and the reason I do that, because, I just got done saying at the seminars or every week I'm here, I say, call me, schedule a 15-minute call, ask some questions, right?
Yes.
I don't want to bill for that because I don't want to discourage people doing it. I don't want people to say, I really had a question. I want to send this guy a question. I want to ask him, but I'm afraid I'll get a bill, for $350 an hour or something like that. And I want to take away that expectation. It's not there with me. It's not there for a reason.
Yeah.
And Do I get people saying to me, "Hey, you're just giving this away, and you could bill for it"? I know that. Do I look? I don't look that stupid, do I? I mean, I get that. I'm choosing to do that because I want to build this relationship with people it's a one of trust. I mean, if you don't trust me, then I don't even want to do business. If you don't trust me, then let's not do that. Find someone you're comfortable with. Yeah. And you have to be when you have an attorney-client relationship. The attorney should not control everything. You're there hiring him. I work for you. Don't ever forget that. I am employed when you hire me.
That's right.
You're what you want is what's most important.
Right.
I have seen circumstances where it's not like that, or people complain to me about that, to other experiences. Now, again, I'm not bashing the way lawyers do things. You do however you want. I'm just saying I've done all this for a specific reason. I do these seminars, and I think I mentioned a time or two, some people that sign up for my seminar say, okay, I want to come to that, but what's the catch?
Yeah.
And I say, no catch. And they say, well, there's no lawyer going to give up 2 hours of his time.
There's so much of that out there, though.
Yeah.
There's so much, and it's understandable for people to think that, this may be some kind of a gimmick to hook me into something.
High pressure sale.
High pressure sales. There's so much of that and I understand why you're having to kind of qualify what you're doing, because people do automatically have that kind of suspicion.
And when we have these seminars, I say, listen, even if you think that and it's hard to get out of your head, come to the seminar and just see for yourself. I'm not going to lock the door and say sign on the dotted line before we let you out. I'm going to talk about stuff. If you have a question, ask. If you don't, you can get up and leave. Halfway through it, you don't like what I'm saying, you can get up and leave. Nobody ever does, but I'm saying if that works out that way, there is no pressure whatsoever. And I offer to people, you can set up a meeting with me called a family vision meeting if you want. Yes. And I tell people, listen, if you come to my seminar and I get your interest up and you say, I'd like to talk some more about that. So we set a family vision meeting, which is up to 2 hours. And it's usually at least 2 hours.
Yeah.
An hour and a half to 2 hours, typically. And at the end of that vision meeting, you say, you know what, I just don't think I want to go forward. We will shake hands and part friends, and I'm not going to send you a bill for that 2 hours. I offer it as an incentive because you came to my seminar, and you can't hear everything in a 1 hour seminar. And we have to talk about more.
And you may have special circumstances that just apply to you.
What we don't talk about at the seminar are your family dynamics. Because I got 40 people at the seminar. I got 40 different family dynamics, right?
Right.
So I don't talk about that.
Right.
But if you want to go the next step and discuss it like that, that's what this is designed to do.
Sure. And
if you don't want to do it, don't do it. So all this is leading up to somebody at the last seminar I did in November. She gave me permission to discuss this, although I'm not going to give names or anything. But
yes.
She came up to me afterwards and said, my husband and I drove 110 miles to come to this seminar. I said, well, bless your heart. Thank you for that. Now, my record is 4-hour drive to come to my seminar. Yeah. Okay. And that person came 3 times. Came once by himself, and then, holy smokes, I got to come here with my wife. No way I can explain what this guy said to my wife. So he comes back with his wife. Then he comes back a 3rd time with his wife and his wife's mother. And then they became trust clients and on. But anyway, she said she drove 110 miles to be here. And then she explained why. She said, we've been wanting to do estate planning for about 2 years. And over 2 years, we went to see 4 lawyers. And we never could talk to the lawyer. We walk in, they hand us an intake form. Or an intake person comes and they said, listen, I want to spend 15. Now, these are an elderly couple, and they want that personal touch, right?
Yes,
and
sure.
They said, we'd like to talk to a lawyer. And the first 2 failed. So the second 2 they went to, they specifically said, I want to schedule time to talk to a lawyer, 15 minutes. We will pay. We're willing to pay to talk to him.
Oh, my. Okay.
And they made it perfectly clear. We want to spend some time with, because they're, and she was thinking, well, they must look at us and think we, just country bumpkins, and they're deciding whether or not they want us as a client.
Right.
We want to talk to the lawyer because we want to decide whether or not we want you as a lawyer.
Sure.
Which is the way it should be.
Yes.
And they never could. 4 times. And she said for the last 6 months she's been looking, trying to do stuff, and she came across one of my seminars. Okay. I think she heard from me on the Nashville radio station because she's from up north of Nashville.
Yeah.
And so she came to it. She came up to me afterward and told me all this. And she said, we scheduled a meeting with you. And she said, we're going to drive another 110 miles here and another 110 miles back for your meeting. And she made it perfectly clear. She said, but we're not going to make a decision at that meeting. If we have to come back again, we'll make another trip for 110 miles to and back. And I said, dear, You don't have to make it. Well, that happened this week. Actually, they were supposed to come earlier, but when we all got snowbound, we had to, to bump it. But they came this week, and it was just like she said. And she came. She's been doing a little homework. She's got a book called The Book of Trust. I don't know who wrote it. I wasn't familiar with the actual book. There's a lot of those out there.
Yeah.
And she had tabs in there, and she wanted to ask questions, and she did, and I answered them, and we went and she explained what this experience did for her. And so I don't relay this by no means like trying to pat myself on the back. I'm relaying it because I think I finally accomplished the vision I had in the first place.
Sure.
And she said, when we were very frustrated with the efforts to try to talk to somebody. Why won't somebody sit down and talk to us? Okay. And I said, I can't answer that. But so she came up and asked me questions after the seminar. And yesterday we had the meeting. At the end of the meeting, she said, well, do we write you a check today for this meeting? I mean, they hadn't decided to hire me yet. They said, we talked about their trust plan. They said, we want to go home and talk to our children about this before we pull the trigger.
Yeah.
And I said, great. You know where I'm at. Call me when you're ready, and we'll do that. And she said, well, do we need to write you a check for this meeting? I said, dear, like I said at the seminar, I said, this is an incentive that I offer people to go that extra step. There's no charge for this. I haven't done anything yet.
Yeah.
We just talked about it.
Yeah.
And she went on to tell me that, she goes, we started listening to you about 7 months ago on the Nashville radio station. And she said, when we listened to you, we started to develop a trust with you, and we never even met you.
Yeah. Yeah.
So we came to your seminar, and we met you. So that trust got even stronger. Now you sat here and talked to us for 2 hours, answered every one of our questions, offered solutions. They had some issues that we wanted. They said, how do we deal with this? And I offered some things. We honed in on things that they like to do. And at the end, at the end of the meeting, she said that, you have done what we have not been able to accomplish. And she said, I don't understand why it's so hard to do this. And I said, I don't understand it either. But this is just the way I decided to do it.
Yeah.
And she was very happy with that. She gave me a hug. I mean, it was just a humble experience for me because I'm thinking to myself, that is the exact response I'm looking for. Develop this trust. Develop this, if
that's a feel-good situation.
And it's the only way to do business. It's the only way to do business when the parties are okay with each other.
Yeah.
And if you, like I said, if you're not okay with me, by all means, don't go with me. Or let's try to see if we can iron out whatever that issue is. But if you've got a preconceived notion, I am trying to correct that. I'm trying to fix it, at least for me in my little world. Yeah. I'm not saying other lawyers should do it or anything. I'm saying I do it.
I completely understand this. I try to do the same thing with my real estate business.
Yeah.
I want a relationship with who I'm working with. I want them to trust me and want to do business with me.
And especially where we are in the world.
Sure.
Here in the South, people are personable. They are polite, they are courteous, and they're personable. I mean,
here's the thing that I find out talking to you, and I feel the same way. You're not trying to sell them anything. Really, you're really not trying to sell them anything. You're offering a service if it's needed for them, but they need to understand what they're getting.
I'm in a great business, and you know why?
Yes.
Just what you said. I don't have to sell anything. My product sells itself, in my opinion. Right. But you got to know what it is before it can sell itself.
Right. Exactly.
And I'm more willing to explain that. So maybe I didn't want to spend that much time on that, but that was just and that's only one story like that.
No,
I'm glad
you did, because I think people sometimes may misunderstand really that this is not about selling you something that you don't need.
That's right.
This is about finding out if this is something that you do need. And we think for a lot of cases you do, but you need to understand what you're getting.
If you
understand how to get where you want to go.
The do need or don't need has to come from understanding.
Yes.
And if you don't understand it, how do you know if you do need it, and how do you know if you don't need
it?
Once you understand it, then you help in the decision process. I often tell people, if I don't want to do a trust plan for you until you think it's a good solution, a good fit for your family.
Yeah.
And when you hear what they do, you're going to come to some solution, conclusion like that. It's just the way it works.
Right.
It is such a grand tool that it works for everybody to some extent. So, again, I say that because that makes me feel good that we finally, this is not the first story. About 3 or 4 years ago, I remember sitting with my staff and say, I think we have actually finally reached what I had envisioned when we first started this. And it's been that way ever since. And that's the way I'm going to keep it because it works good for me. It works good for the clients. We have a relationship. They don't worry about asking me a question.
Right.
And even my trust clients, after years after they do a trust, they'll have a question and they'll call, and they'll say, I have a question. I know you talked about this, but I forgot about it. And how's that work? And it's part of what I do.
Right.
And they'll say, well, can you send me a bill for that? And I said, no, I don't do that. It's part. You're a trust client. It's part of what I do. I want you to understand. No problem. I don't expect you to remember everything we talked about.
Right.
So again, that was just very humbling for me.
Awesome.
This was really cool. So anyway, one thing I do want to talk about today, it may not take the rest of the time, but also very important. I've been saying all along, everybody should do planning, right?
Sure.
Trust plan or
Absolutely.
will planning. But one thing I say people should do regardless of age. I don't care if you're in your 20s or your 80s. Everybody needs a power of attorney. Power of attorney is not planning after death. It's planning during life.
Yes.
Because the power of attorney expires at death. You can't exercise power of attorney after death. Now, and a power of attorney is I often explain to people, a power of attorney is if you ever in a situation, whether it's an incapacity or you just, want to take a 6-month vacation or something.
Yes.
You want a trusted person to take care of business for you and make decisions for you. A trusted person, it's usually a relative like a child, but it doesn't have to be. But
Yes.
A trusted person knows and understands what you do, what you want, and will act in your best interest while you're either gone or incapacitated, right? Now, the problem with power of attorney, and the reason I say you need it at any age is because stuff happens, right?
Stuff happens.
And I can't tell you how many times something has happened and we don't have that.
Yes.
Now, what happens when you don't have one and you need one? Let's talk about that. That's when it gets complicated and expensive. If a power of attorney, if you come to me and say, my wife and I want to do power of attorneys. That's all we want to do is power of attorney. And I won't get into the fact that when you have power of attorney, there's 2 of them, one for healthcare and one for everything else, right?
Yes.
The durable general power of attorney. We usually always do them collectively, but like you say you want power of attorney. It's very inexpensive. I mean, it's like $200, $250 or something like that. It's very inexpensive documents to do.
Yes.
And now when you do that, you're set. So if you become incapacitated, you've already named somebody that's going to now become the what they call the agent. You're the principal. They'll be the agent, and they'll act for you.
Yes.
And it's going to be your spouse, or it's going to be one of your adult children, typically. But it can be anybody. But it's a trusted person that you picked when you were of sound mind and disposing memory, right? You sat
Yes.
down in my office and said, who do you want to be making decisions for if you can't make them? Well, I trust this child, and I think I'm going to. So
Yeah.
you pick the person, and that's who you get when you do that. Now, this is a power under our we are a General Durable Power of Attorney Act state.
Okay.
And this power is somewhat of a non-delegable power. Okay, the person has to give it. You can't delegate it. You have to empower somebody as an agent. Okay, and you do that through signing of this power of attorney document. Now, what happens if you have an accident and you go in a coma? Let's use that for an example.
Sure.
Let me use an example that I've seen at least 3 times. You're in a motorcycle accident.
Yes.
You suffer brain damage, and you're in a coma. Now, you are definitely incapacitated, right? Now,
Yes.
if you have a power of attorney, that baby springs to life, and your agent is on board from the moment of the incapacity, right?
Okay.
And it can be before. It can be. You don't have to be incapacitated to have somebody, but I'm going to stick with the incapacity for an example.
Yeah.
What if you don't have one? What if you're 20 years old and you say, "Nah, don't worry about that. That's what old people do. That's what guys like my age do, and I'll worry about that later."
Right.
And you don't have one, and that happens. Because
Right.
motorcycle accident is not age specific.
No, it is not.
Well, it might be because older people are smart enough not to get on one.
Yeah. Got a point there.
If you're a motorcycle fanatic, don't get mad at me. I'm just saying. But I've had a couple of that very incident, and especially when you're young and you're incapacitated now because of this accident, and now you got a young wife at home with minor children. Now you don't have a power of attorney. What to do? Okay, well, the wife says, well, I need to do this for my husband. Well, you haven't got the authority to do it. But I'm married to that person. We're married. Marriage does not grant power of authority. I mean, whether you like me for saying that or hate me for saying it or somewhere in between, that's not Stan saying it. I'm just relaying to you what the law is.
Right.
You go to the bank and try to deal with money that's just in your husband's name. Now, if you have a joint account, that's different.
That's
right?
different.
If accounts Stan and Tammy Tammy can do whatever she wants without my approval, and I can do whatever I want. So if I'm incapacitated, she certainly has access to that account. But if it's certain things that are the husband's or certain things that he deals
Sure.
with, you cannot without this authority. Now, here's the problem. If you don't have it and you say, okay, I need to get one, who's going to sign it? The incapacitated husband? Well, not. He's no longer of sound mind and disposing memory.
Right.
Via the incapacity. So what's to do? I'm going to tell you right now, there's one remedy and one remedy only, and that is called a conservatorship. Now, a conservatorship, everybody's heard the word, right?
Yeah.
Some states call it guardianship. So if you're from somewhere else, it's the same thing. What if you hear the word conservatorship, let's insert some other words to make it understandable.
Okay.
Conservatorship is a court-ordered power of attorney.
I was going to say it had to be court ordered.
There's only one thing. When things get done involuntarily, the court's the only one who has the power to do that.
Yes.
I mean, it's involuntarily because the person's in a coma.
Right.
And the court's doing it for him, right? The court's the only one can wield that kind of power. And so you have to go get a conservatorship. And I'm not going to get into the nuts and bolts of the conservatorship, but I'm going to tell you, it gets pretty expensive. It is about a factor of almost 20 what the power of attorneys would have cost.
Yeah.
I mean, you got to hire an attorney, do the petitioning attorney, and when you file the petition, you got to have medical records, which you got to go get. You've got to name people. Now you've got to name all these family members that could possibly serve, and then elect somebody that the petition is promoting to serve as the best person. So in a sample like that, it would probably be the wife. You know what I mean? But the person in the motorcycle accident has a brother, maybe a sister. Other people, maybe a still living parent, they may think, well, the wife's not the best person to be a power of attorney. I think I am.
Yeah.
Okay. Well,
here we go.
You got to notice everybody. Okay.
Yeah.
You got to notice everybody up, and if you think we're purporting to the court, we're suggesting it be the petitioner, which is the wife, but anybody in a certain level of consequentity or affinity can throw their hat in the ring. That means a close relation.
Right.
Okay. So they can throw their hat in the ring, and the court will decide. But you're entitled to be heard. If you think, you know what, his wife is, she's not suited for this.
Right.
I want the job. Well, nothing happens automatically. The court's going to decide, and the court's going to. It's a matter of proof at this point. So you got to come in and show why the wife shouldn't do it, and first of all, and then you got to show why you're the better person to do it. Now that doesn't happen often, but it can. But so that the petitioning attorney is hired, and I say the fees I see for conservatorship are anywhere from $2,500 to maybe $35,000 or $4,000.
Yeah.
Now I'm not done yet. Now you got to go to court. You got to pay the court fee.
Yeah.
So conservatorship, I can't remember. So if I'm wrong, there's fees for everything you do in court, and they're all different. That one I think is in the neighborhood of $450 or $500.
Okay.
Okay. So there's a filing fee. That's a cost.
Yeah.
And when you do that, you file a petition to the court and say, hey, my husband is incapacitated. He needs a conservator. The key word there is he needs a conservator. And two, I want to be the conservator. Okay, so when that happens, the court does not just not take your word for it. Okay,
Yeah.
It's a protection. And so the court appoints an independent person called a guardian ad litem. And that's another attorney. And that attorney's job is to go talk to the incapacitated person or make a determination whether or not that person really needs a conservator, right?
Right.
Look at the medical records, make a determination. Does this person need one, first of all? And if he decides yes, of course, if he decides no, it kind of ends there, right?
Right.
But if he decides yes, this person's in a coma, he can't make decisions for himself. Now he probes into all these people that could be in line for the job to see who the best person is.
Yeah.
And if the petitioner is the best person or not. Okay? And so
Wow.
he talks to people. Then he submits an independent report to the court. Independent, meaning he doesn't ask me who I think is the best. You know what I mean? Stuff like that. It's
Right.
independent. He decides for himself. That's what a guardian ad litem does. And he submits that report to the court. Then we get to a hearing with the court. Now we have to deal with issues like if somebody wants to be heard for some reason, we'll schedule a hearing. That whole process is typically anywhere, when you're all said and done with it, that whole process is going to cost anywhere from $5,000, maybe not as much as $10,000, but typically in $7,500 for this. Eventually, you end up with an order from the court appointing somebody the conservator, and the order lists all the things that they can do, just like a power of attorney document did. And so you end up with a court-ordered power of attorney, right?
Interesting.
And you get there. Now you can finally act. And that's
But it's
the only.
cost you so much more.
It does, and that's the only remedy that you have if you don't have one, and something happens, and you've now lost the power to give it.
All right.
And it doesn't end there, because once you're a conservative, now there's a duty to report to the court every 6 months.
Question for you. You knew I'd have a question.
Oh, I hope you have a question.
Okay. Okay.
I'm surprised you only have one.
Well, probably more than one. Pardon me. The need for a power of attorney. You said pretty much everybody needs a power of attorney, but I would think now, first of all, they would have to be an adult, because the need would come in an adult that has possessions, or am I missing something?
Well, if you're, you mean the person acting as agent?
I'm just trying to figure out. I'm trying to think about the all the benefits. What are the benefits of having this power of attorney? Of course, you went through one scenario there, but let's say you're supposed to be an adult at 18 years old.
Correct.
Okay.
That's legal adult.
Legal adult at 18 years old. But usually, normal folks at 18 years old don't have a lot of possessions.
Correct.
They might have a bank account,
Right.
something like that kind of thing. But they probably are not yet owning real property, but they might.
Right.
But,
I agree.
Those kind of things. So I'm thinking. So the possession things or things of ownership are what and what has to be done with those things and decisions made, even health decisions, which you're talking about, for someone who's incapacitated. So I'm thinking, I guess, you really need one fairly early on.
Well, again, even if you have nothing estate-wise, possession-wise, you certainly need the health one.
Yes.
Because that has to be determined because,
Yes.
I mean, your health care is you're in some kind of health care, and that comes with a cost.
Right.
So, at the very least, you might be dealing with an 18-year-old that has insurance. Somebody's got to deal with his health insurance.
Right.
Somebody's got to deal with his car insurance. Somebody's got to pay his light bill. There's stuff like that.
Yeah, that's right.
They're just the daily things that you can't
once
do.
a person has some kind of independence as an adult, and they've got their own bank account, they've got their own insurance policy, and some kind of decision has to be made regarding those accounts, you can't do it if you don't have power of attorney or authority to do so.
And if the principal's incapacitated, nobody can do it until somebody gets ordered to do it.
Right.
So I don't think what you own is a determining factor. Yeah. It's so easy to put into place.
I'll give you an example that's just even in my own household. Teresa and I, our health insurance, we have two different sources of health. I have one policy with one company. She has with another. And as it sits, I can't call and talk to her insurance about anything. She has to do it.
You are exactly right, and this surprises people.
Yeah,
we do a lot. I'm not going to get into the 10-care planning, but when we do a lot of 10-care planning, we deal with assets. Somebody's in the nursing home. Let's say Dad's in a nursing home and Mom has his power of attorney. Okay.
Yeah.
We go to the nursing home and say, hey, we want to surrender this thing or cash this policy out because we're trying to pay for long-term care or whatever.
Yeah.
They're going to say, well, we can't talk to you.
Yeah.
And to say, I'm talking about Mom calling. We can't talk to you. So how much power of attorney? Okay, great. Send us the power of attorney form, and we'll run it through the legal department first.
Yep.
And if we like the power of attorney or think it passes muster, then okay, we'll talk. Well, usually in 10-care planning, we're pressed for time.
Yeah.
And 7 to 10 days to look over the power of attorney, right?
Yeah.
And then finally they'll say, okay, we can talk to you. And they'll talk to you. And so you're right. Being married doesn't give it to you.
Yep.
And if you say, I don't have a power of attorney to give you, they will not. Why? Well, they don't want to get sued for HIPAA. They don't want to get sued for insurance fraud. They don't get sued. They're not going to give. They're not going to. They can't. Okay. So you're right. Now you mentioned about age. Now we're talking about power of attorney. You got two parties. You got the principal, which is the person appointing someone to act for them, and the agent, who's the person that is acting. Right.
Correct.
As a principal, you can have a power of attorney as a minor, but it's your guardian doing that, your parent.
Yes.
So when we do trust plans and that you have a minor children, part of that plan is the guardianship issue. And so they have, if you appoint a guardian, they're going to also appoint power of attorney for minor child and a power of attorney for health care for a minor child.
Yes.
So we can that exists, but it's not the child that gets it. They got to be 18 years old before they can make their own decision as who they want to have. Then they can do their own.
Yeah.
Up to 18-year-olds, your parents do it for you, or your legal guardian. Now, and also, you have to be that age to act as agent.
Yes.
You have to be of age of majority.
Okay.
So, because and don't get mad at me if you're under 18 years old and you're really smart and you could probably be emancipated legally. The laws of Tennessee said you are not an adult.
That's correct.
An adult is a legal term. It's not meant to be insulting. And if you're not an adult, you're a minor.
Yes.
And you might have a 17-year-old that could act as adult better than most adults.
Yes.
It's not meant to be that way. He is not legally. That person is not 18 years old. Right. There's an age called the age of majority. And if you're not, you're not. Now, if there's a need for you to be age of majority when you're not physically age of majority, we have an emancipation process where you can do that. Yeah. And so we can overcome that. But nonetheless, that's what the law says. So if you're not 18 years old, there's a lot of things you can't do. Your parents are still in charge.
Interesting.
If that makes you mad, think of the good parts of that. You can't get sued.
Yeah.
Your parents get sued. Yeah. You can't be held liable for a contract you enter. If you're 17 years old and you go out and you buy a Tesla, okay,
yes.
you sign a purchase agreement for $120,000 to buy a Tesla.
The salesman wasn't watching.
And you haven't got $50 in your wallet. Yeah. And when it comes time to make the payment, you say, I haven't got it. Well, they can't sue you for it. And they really can't even sue your parents for it. I mean, they could possibly sue the parent. It's circumstance oriented, but you can't be held responsible for your debts when you're a minor. Okay. Now, I don't say that.
We don't need to broadcast that, probably.
Well, I'm not saying go do that because your parents are on the hook.
That's right.
Because you're a minor, they are your legal representative.
Yes.
And so they're responsible for your acts. And, that can suck for the parents, okay? But anyway, I'm just saying that if you're under 18 years old, there's a lot of things you can't do legally. There are some things you can do. When I talk about doing wills,
yes,
they have to be witnessed.
Yes.
In the statutory scheme for wills, it talks about who can witness a will, and it specifically says anybody 18 years of age or older.
Really?
You can be a witness in court. Okay, when I used to do jury trials, right?
Yes.
I could subpoena a 3-year-old. If they could answer questions, okay.
Yes.
In some of the things I've subpoenaed teenagers.
Yes.
I can subpoena them as a witness all day long, no problem. At any age. Right. To be a witness, you just have to have knowledge. You have to have knowledge of the facts that you can testify to.
Sure.
Right. But if I want a witness to be a witness in these legal documents for a will, it requires a witness that's 18 years or older. So there's a lot of. And there's a reason for all that. It makes sense when you think about it. Typically, if you're a minor, you haven't got the life experiences, the wherewithal, the mental, cognitive processing power. Somebody may argue with me. Some people do, some people don't. But you got to draw the line somewhere, right?
Well, there are definitely variables in maturity, I guess, with kids.
Thus, the voting laws, the selective service laws to be drafted. When we used to have that, there's got to draw the line in the sand somewhere of when you're able to do stuff and when you're not.
Yeah,
it has to be a one-size-fits-all, really. So anyway, but you had asked about the age, and that's that. And I don't now the age, like I said, the age to have one. I don't think your state should be a determining factor for a couple of reasons. One, there are always decisions that have to be made, but for two, you always want some. There's decisions do have to be made, and it's so simple to get one. I mean, it's very inexpensive and very easy to get one. Yeah. So why wouldn't you have one? Now let's take it another step further. Let's say you got somebody on the street. Now you got somebody on the street. They have nothing. I mean, they're just what we call indigent, and I don't know. They get hit by a bus and they're in a coma. Let's just make it up. Incapacitated at some point in time, and there's nobody there to throw the hat in the ring to be a conservative. It's just somebody that has nobody.
Right.
I don't know how to. I'm painting the picture pretty clearly.
Sure.
Just somebody that has nothing, has nobody, or if they do have somebody, it's a situation they just don't want to be involved. You can't make somebody be a power of attorney.
Right.
You can't make somebody be a fiduciary. So they have nobody. Well, you've heard of things like the public defender and stuff like that.
Oh, yeah.
Well, we have a public conservator.
Oh, really?
And so, if this is what happens, and I don't want to paint this picture, but this is what happens when some people take grandma or mom and go park them on the step of a nursing home and then run away. Okay, which I had a case one time like that. As egregious as that sounds, and nobody wants anything to do with her. So she needs to be taken care of, right?
Yes.
And who's going to make decisions for her? Who can make the decision to even admit her to the nursing home or a hospital?
Yeah.
There's nobody. So we need somebody. So when there's nobody, somebody will throw in the hat for a petitioner, and they'll get people that do the public conservator that'll raise a petition to the court and say, here's a person, has nobody. We've done a diligent search. We can't find any family members. Or if we did find family members, they told us to go pack sand. I don't want the job. You know what I mean?
Yes.
Which can happen.
Yeah.
And there's nobody ready, willing, and able. Okay?
Correct, okay.
And so we have nobody. And we need somebody to make decisions in this person's best interest. So it's a conservatorship just like rest, but now it's governed by the public conservator. And the court will appoint a person that's in the public as a public conservator, which is typically an attorney. Okay. And that person will now make decisions for them. Now, what's the downside of that? Total stranger, don't know what they want, have no clue what they might have wanted when they were able to express what they wanted.
Yeah.
But the good side is, I mean, a public conservative will do exactly what they need to do without bias or fear. You know what I
Yes.
mean? If you got other family members that go to them and whine about it and say, well, they're not going to listen to them. They're going to do what the conservative laws say to do, which means act in the person's best interest.
Yes.
Now, sometimes when you're dealing in someone's best interest, you're kind of guessing. Because if it's a family member, you probably know what their best interest is, right?
Yeah.
But if it's not a family member,
You have at least
you
some
have to look
clue.
at it in terms of generality. And if you're a reasonable person in a reasonable standard in life, this would be in your best interest.
Yes.
But I mean, is that person in a reasonable standard, or do they have specific circumstances? We don't know because they're incapacitated and nobody stood up for them. It happens. Now, it's not overly common, but it happens enough that we have a public conservator
You had to put a system
set
for it.
set of rules to deal with that.
Yeah.
It happens a lot in big metropolitans and stuff with homeless people and stuff. It happens often that way.
Yes.
And it needs to be in place. So, but the point is, the whole real takeaway here is, I think you need it because we're dealing with the what ifs. Well, I don't need it. I'm too young. Well, you're not too young to be in a car crash.
Yeah.
And although I try not to have road rage, I'm telling you, every time I go out there, you have a high probability of being in a crash. I don't care how safe a driver you are. It's usually not you, the one that caused the
It
accident.
seems to be increasing that way every day. So.
And I don't want to get off on this, but the other day, I pulled out of Weekly Creek Road on 64 heading toward Pulaski.
Yes.
And I can see way up, and there's a curve, but I can see pretty far away.
Yeah.
And as I pulled on, I saw a car come around. I couldn't even tell what lane it was in. It was too far away. So I pulled over and got in the left lane first. And as I got up to speed, I turned the signal on and got in the right lane, just like you're supposed to do.
Right.
And I looked in the mirror, and the car was getting closer, so I knew he was going faster than me. And now he was in the passing lane. And so I looked, and I said, well, I'm going to move over to the right because I hadn't got up to speed yet. So I moved over to the right. And I went to look in the mirror to see where he was, and he wasn't there. And all of a sudden, I saw something out of my right peripheral. This guy passed me on Route 64, where it's a 60 mile an hour speed limit, on the berm, on my right. I'm in the right-hand lane. And
Yeah.
so when past me is the white line.
Yeah.
And then the part of the road that
So
is
he'd
the
been on
side
the
of it.
shoulder.
At 70-some miles an hour. I mean, he blew by. And I'm thinking, I like to think myself as a safe driver.
Yeah.
I had no control over that circumstances. I looked, I saw him. I looked again to see where he was. He wasn't even there. Next thing I saw, he's in some odd place. I mean, it just... So, if you don't think you need a power of attorney, please
Yes.
reconsider. I'm not saying come to me and get it. Any attorney can write you a power of attorney.
Yes.
Get one. You just need, and you can do ones online. Now, I'm not a big fan of online stuff, but power of attorneys are a little harder for them to screw up. You know what I mean?
Yeah.
Now, the only thing I think about power of attorneys that need to be done is if you're thinking about doing like a trust plan or something,
Yeah.
we need to put language in there that makes your agent able to deal with that plan. And that's
Yes.
not typically in one.
Okay.
The typical language I see is if you already have a revocable trust, your agent can fund property into it. Now, what we want to have is we want to be able for them to establish a revocable trust or establish an irrevocable trust for you.
Okay.
Or certainly deal with the ones you have. But, and the reason I say that is we had a court case out of Tennessee where a guy was POA for his mom. She was
Yes.
incapacitated.
Yes.
And they had a business and a fair amount of wealth. And he wanted to protect her assets from the high cost of long-term care. So as power of attorney, he created an asset protection trust for her. It wasn't one of mine. It was somewhere else in Tennessee. But he did that. And, of course, then his sister complained. They went to court. And the appellate courts ruled that, okay, as power of attorney, it says he can establish irrevocable trust. The only other standard in the power was he just has to do it in her best interest.
Okay.
And they talked a long time about her best interest. The bottom line, which I thought was great, was our appellate court said putting property in an asset protection trust to protect mom's wealth from the high cost long-term care is most certainly in her best interest.
Yes.
And so, some attorneys might say, well, we don't want to put that in because in a trust you can say everything goes to you. Okay, I mean, we don't taint it. We don't do stupid things like that. But we have the ability to create the trust and stuff like that. And the courts have sanctioned that. So it's okay. So, but if that's one of those powers, we call them a non-delegable right. And what that means is you can give this right away, this power to your agent.
Yes.
But it has to be expressed in the four corners of the document. So when you get a power of attorney that's half a page long and it says something like, I incorporate all the powers of the code by reference. Now, you can do that. And the code even says you can do that. But when you do that, it does not include the expanded powers. Those powers are ones you have to put in. If it's not in the four corners of the document, you have not passed it to your agent. So when you see a power of attorney that says, my agent can do anything and everything I can do,
Okay.
sounds like it means anything and everything, doesn't it?
It does.
Well, it doesn't include the things that have to be express, the enhanced powers in our code. You have to put them in the document. And
What would be an example?
dealing with trusts.
Okay.
Filing tax, doing tax stuff, certain tax stuff.
Okay.
You know, the IRS has a tax form. I forget the number. I want to say 8904. I can't remember.
They have
but
too
it's
many.
their power of attorney.
Yes.
Okay, and it has certain language in it. So the way to overcome that, so you don't have to, suppose you're incapacitated, how's it going to sign an 8904 or whatever it is? Well,
Right.
what I do is I just mimic the language in that form into the document,
Yes.
and they'll accept that.
Yeah, that's interesting.
These general power of attorneys, I've seen them balk at.
That's amazing.
I mean, so there's a lot of reasons why. And again, when it's so easy to do, so inexpensive, and it means so much, I'm telling you, I think if everybody could experience somebody who doesn't have one and has to go through this conservatorship thing, then I wouldn't have to talk you into it. If you could,
You're right.
if you could see what happened,
Yeah,
there'd be
you're
no
right.
talking into it. It'd be your idea, because this is what. And again, if this happens to you, who's the one bearing the cross? Your family.
Yes.
It is a tremendous burden. Now, conservatorships, when you name your wife, when the wife is going for the conservatorship and everybody's on board with it, they go relatively smoothly. But they still take several months to get there. And the
Right.
cost doesn't go, the cost is not cheaper because it goes smoothly.
Right.
The cost is more because if somebody wants to contest it. So, so it's expensive. It takes a pretty long time to do it. Meanwhile, the 3 or 4 months it takes to get to the conservatorship, you got all these people screaming to get paid. Nobody has the authority to pay them. You get these threatening letters in the mail. Hey, this guy's in the hospital. They don't. It's a stressful time.
I had a friend who passed away. It's been a few years ago, and he had a business, and his wife had to take over the business. Well, there were bank accounts and things like that
In the
that she
business
had-
name.
Yeah, she had no access to. She had no access to bank accounts. They shut everything down, and she had to go through a big process, just like we were talking about, to get everything. And it took like an act of Congress to get it all done. Now she finally got it all worked out, but that problem could have been solved with what you're talking about.
Now you can solve that problem, but you got to involve the court.
You got to, yeah. Well, I'm talking about prior to. If she'd have had the.
Oh, that's right. Absolutely.
If you'd done the stuff ahead of time, if they'd thought about it.
Very simple.
It was a sudden, event,
yeah.
and it happens.
Nobody plans to
Yeah.
be incapacitated.
Yeah, it happens.
If we saw it coming, we'd do a power of attorney an hour before it happened, right?
Yeah. But I remember her going through that, and it was like pretty stressful. Not only had she lost her husband, but my goodness, now she's lost access to their bank accounts and all this kind of stuff that was needed. There were people that needed to be paid that she couldn't pay. There was a lot of stuff going on.
If you don't believe that doesn't happen,
Yeah.
try doing this if you have the time, energy, and effort to do it. Go to the bank and open a bank account, put $100 in it, or the minimum, $50, $100.
Yeah.
Then tell your husband, go get that money out of the bank. See if they'll get it.
They not wait. It won't happen.
Sometime in small towns, some of that stuff can go on because they've been married for 100 years, or something like that. But you do it with a bank like Wells Fargo, Bank of
Yeah.
America, somebody that's everywhere.
Yeah.
And see if somebody not on the name, and you're the only name on the account.
Yeah.
See if somebody else who doesn't have the name on the account can get that money.
Yeah.
Now that when you find out what I can tell you is going to happen, the answer is going to be you can't, you
Yeah.
won't, and you can't. Okay. And now when that can't, now let's just extrapolate that to husband and wife. If your
Yes.
husband has a bank account in his
Yeah.
name,
Yeah.
and he becomes incapacitated, you are SOL for getting into that unless you have a power of attorney that gives you authority to do what he can do. He can get into it. Now, if he can get into that bank account, now you can as his POA.
Right.
So
Right.
it's, the concept is simple, but it is a legal maxim. We have to be in compliance with it, and it's for the people's protection. Not anybody can be a POA willy-nilly because you know as well as I do, you have people out there that will pilfer the guy's
Yes.
account.
Yes.
And that's what the protections are to prevent.
Right.
Here's what happens sometimes. I know we're getting close to the end, but here's what happens sometimes, and this is why the court doesn't take your word for it.
Yeah.
People file petitions saying Aunt Gertrude needs a conservator. She's got several $100,000, and she needs a conservator because of this, that, and the other thing, and she needs protected. The guardian ad litem gets appointed, goes out there, and tells Aunt Gertrude is sharp as a tack.
Yeah.
She's got her mental capacity, no cognitive impairment whatsoever. Is somebody trying to get at her a couple $100,000?
Probably.
And that's the check and balance. And the guardian ad litem comes back and says, I'm advising the court not to approve of this conservatorship, but she doesn't need one.
Yeah.
Somebody's trying to get at her money.
Yeah.
So you don't go in and say, hey, she needs a conservatorship. The court says, okay, you can take care of things.
Yeah.
It does not work that way. That's why it's expensive. That's why it's long and drawn out.
Right.
These protections are built in, and they need to be. But they also take time and they take money. Yeah.
But if that person has a POA and somebody she trusts, then we're in business.
We never talk to the court.
Yeah, you don't have to.
No, you go to the bank and they say, now let's go back to the example of the $100 in the bank account. And the husband says, I want that $100 on my wife's bank account.
Yeah.
Well, and they say, well, under what authority are you acting for your wife? And you take out this document and say, under this authority.
Yeah.
And the bank will recognize that immediately. They say, okay, what do you want? How much is in there?
Yeah.
$100. What do you want to do with it? I'm going to write a check on this account for $100 and close the account. They'll do it. They'll do it. Now, that's a proper way. That's a proper exercise of the rules.
Right.
And
right.
That's what we want. So, anyway, we're getting close to the end. But I want to
remind about your seminar.
Yeah, I want to remind about. But that was a cool discussion, and I think that's so important. If you
you
don't do anything at all, do a power of attorney.
Yeah.
And do it for everybody in your family.
Yeah. Yeah.
You know.
I agree.
So anyway, we're going to do this seminar. We call it Wills, Trusts, and a Nursing Home. That's kind of the three basic topics we talk about. And it's Saturday the 17th. Now that is a week from tomorrow. Tomorrow's the 10th, so next Saturday. And when we do Saturday seminars, we do it at 10 o'clock in the morning.
Yes.
And we're going to do it right here at WLX on radio station. If you need something to put in your GPS, the physical address here is 1212 North Locust Street. Or is it Avenue?
North Locust Avenue.
North Locust Avenue, Lawrenceburg, Tennessee. And that'll bring you right here. And when you get to the building, the radio station's up front and the sign.
Yes.
It's a big, long building. Used to be a bowling alley. Come to the back of the building. There's a set of double doors there. Just come on in, and that's it. That's what they call the Country Cafe. Now, don't come thinking you're going to stay for lunch. I've had people who haven't been familiar with the place say, well, after your seminar, we'll just stick around for lunch. Well, it's not that kind of cafe.
Not that kind of cafe.
But it's a cool place. It's big, plenty of room. Again, come to that. If you want to get signed up for it, call my office at Pierchoski Estate Law, Pierchoski Elder Law. The number there is 931-363-7222. I'm on the square in Pulaski. Pop your head in and say, hey, I want to go to that seminar, or call me. Or you can go to my website. It's easy to get to. It's technically it's PierchoskiEstatelaw.com, but if you don't want to spell my name, just type in estateplanstand.com and it will go to my website. There, I think you can even RSVP from the website. Or you can get the phone number and call, or you can email me and say, hey, I want to come to the seminar. We won't bug you about it. What we will do is we'll ask for a phone number or an email, and a day or two before, you'll get a call from probably Miss Courtney just saying, hey, just want to remind you the seminar's on Saturday at 10 o'clock. Now, a lot of people say, yeah, I'll be there, or some people say, you know what, something's come up, I can't be there, and usually they'll say, when's the next one, and stuff like that. But And if we get a voicemail, we just get a voicemail. We won't call you. We'll leave a voicemail, and that's it. Sure. Just a reminder.
Sure.
We try not to abuse that. And if you think we call you too much, let us know. We'll stop. Again, that puts us, in less than 20 seconds to go.
Yeah, you did good.
Yeah.
You did very interesting today.
And we're always here every Friday from 8 to 9 with Bulletproof Estate Planning. With me, your host, Estate Plan Stan. Think of a question between now and then and ask it. Call in and ask.
Yeah, very
I welcome it.
Very interesting discussion. The power of attorney and the importance of that for you and everybody. And then, of course, leading into the fact of just planning ahead.
Absolutely.
Planning ahead. That's what you're all about. Estate Plan Stand, everybody. Bulletproof Estate Planning. That office number 363-7222. Don't forget the seminar coming up on the 17th here at the Country Cafe. God bless, buddy. We'll see you next time.
Always a pleasure, Jeff. Thank you.
All right, buddy.
He's not there.
GOP Congressman Ralph Norman tells Fox Business.
Our foreign adversaries sense blood in the water. They sense weakness.
This after Spencer.